If you think the governor of New York and the legislature are insane, please like and subscribe because they are. Good afternoon. I'm Patrick McGee. I'm a Florida trial attorney and former police officer, and I bring you firearms and gun related information from around Florida and around the country. We have insanity going on since the Bruen decision. States of New York and California are just doubling down and basically openly defying the Supreme Court in their Bruen decision. Just the other day, the New York State Police issued their requirements for the qualification on firearms, the classes, and the accuracy qualifications, and we'll go over those in just a second. After the Bruen decision, the state of New York doubled down and issued the Concealed Carry Improvement Act, or the CCIA, as they like to call it in acronyms in government, because everything needs an acronym when you're dealing with government. Anyway, it doesn't improve anything. It doubles down on their subjective standards, and this law is supposed to go in effect on September 1st. And just last week, the New York State Police issued the requirements for the firearms training. So let's take a look at those now. All right, you should have before you the minimum standards for the New York State Concealed Carry Firearms Safety Training, issued August 23rd from the New York State Police. And this is in relation to their Concealed Carry Improvement Act. So let's hit the pertinent parts. 16 hours of live in-person classroom training conducted by a duly authorized instructor. These are all the subjects you have to cover. After the 16-hour in-person class, you have to take a test and score 80%. So everybody go back to school and get your study habits up. Authorized instructors have to maintain records of student performance on the written exam for 5 years. What will they do with that information, I wonder? And shall make records available upon the request of a licensing officer or designee. So the state will have access to your training records. Live fire. You must have 2 hours of live fire. There are 6 areas in the live fire, and you must demonstrate a minimum proficiency. On command, you aim at a target and fire 5 rounds from a standing position from a distance of 4 yards. The target must be 25 inches by 11 inches, a paper target, and 4 out of the 5 rounds must hit the target to pass. You can use live ammunition or simunitions. Instructors have to keep records of your performance for 5 years and make them available to the state. So therefore, there you go. There's the standard for the training portion of the New York Concealed Carry Permit pursuant to the New York Concealed Carry Improvement Act. And this just came out, so what, 8 days before the act goes into effect. It goes into effect on September 1st. Okay, so there you have it. That, along with the social media review, the letters of reference, the neighborhood interviews, and all that other stuff. What New York has basically done is thumbed its nose at the Supreme Court. They've doubled down on places you can't carry, so basically makes a lot of the state, even if you have a permit, you can't carry. And the subjective leeway that it gives permit issuers is, worse than it was before. The previous scheme, I think, would have been easier, at least outside of the New York City area. So there you have it. I'm sure this will be a battle. There's already been a lawsuit filed trying to get an injunction on this particular case. They had an injunction hearing, and the judge said that he would issue an order on the injunction prior to September 1st when the act goes into effect. And I will bring you that information as soon as I see it. But for now, for the time being, if you're in New York, it's just an insane situation if you want to exercise your Second Amendment right. Thank you for joining me here on Lawyered Up. As always, I appreciate it. And remember, if law enforcement comes knocking, the first thing you do is lawyer up.